What are the types of workplace sexual harassment? Attorney Andrew Campbell explains that quid pro quo harassment is the rarer of the two forms of sexual harassment. It involves a direct or indirect request by an employer to submit to sex-based conduct or communication in return for either getting a job or keeping a job. An example would be a supervisor asking an employee, "Hey, if you perform this sexual act for me, I will help you in some way," such as a raise, a promotion, or a positive performance review. A person would like to have a claim under this theory if their submission to or rejection of that request is used as a factor in decisions affecting that person's employment. So, if a person were fired, demoted, or given a poor review for rejecting that request, they could very well have a claim. A quid pro quo claim always results in direct economic harm to the victim employee. The direct economic harm, however, must be more than brief or temporary in nature. For example, where an employee is put in a different or less desirable job for 10 days with no change in income, a court would not likely find liability. These types of claims are fairly rare because they are very difficult to prove. Not many persons in power would put such requests or conditions in writing or in a place where they could legally be recorded. So workers employed at isolated locations are particularly at risk. The far more common type of sexual harassment is known as hostile work environment. The U.S. Supreme Court has explained that quid pro quo harassment results in a tangible employment action based on the plaintiff's refusal or submission to a supervisor's sexual demands, whereas a hostile environment claim is one where threats of adverse action were never made or were never carried out, but the harassment was severe and pervasive. In both types of harassment, the conduct must be unwelcome. The Michigan Supreme Court has stated that the threshold for determining that conduct is unwelcome is that the employee did not solicit or incite it, and the employee regarded the sexual conduct or communication as undesirable or offensive. For a free phone consultation, contact attorney Andrew Campbell in Flint, Michigan at 810-620-7799 or visit his website at www.michigandebtabuse.com.